Find probable cause for aggravated battery. I'll hear from you, Ms. Corey.
Judge, at this time, Mr. Levi is currently homeless. The TAP program will not accept this
Right.
case, so.
I thought it was a psychological issue.
Uh,
Mr. Land, you are to have no contact with Heriberto Ramos. State with regards to bond,
7,500.
7,500 will be the bond. James or James Streeter? Is it James or James?
You know, he's on felony bond in 4 cases.
You know, again, count 2 should be a grand theft, I believe. But no, right now grand theft is 750. So it is petty theft.
Corrections, this is an added charge or no? Not
No,
added.
ma'am, there's a new charge of tampering with physical evidence and petty theft. He is to be held on the current cases. Tampering with evidence will be 1,000. Petty theft will be 250. Does he go to court tomorrow?
Yes, sir.
Okay. I was just asking, so I don't know whether I have to announce it or whether it's automatic. Okay, so there's an order prohibiting him from going back to Harbor Freight. Francisco Ortiz,
Bonded out.
James Denton. Mr. Denton, you're before the court, having been arrested for aggravated assault, burglary with an assault and battery.
I just realized that. I apologize for everything. I thought I sent the motion on this one, but I realized I did not.
You are to have no contact with M.A., who is the alleged victim in this case. I find probable cause.
Judge, it looks like the alleged victim is at their property without permission. They're demanding that he leave. And it looks like he's refusing to do so. And that's why this incident's occurring. So it looks like they're defending their property, Judge.
With a firearm. You are to have no contact with M.A. The burglary deals with the
It must be the vehicle portion. That's why.
vehicle, but then, you know, they never entered. It was,
No.
everything happened outside. I don't find any probable cause to burglary with an assault. I do find aggravated assault and battery. To the aggravated assault, what is your bond recommendation state?
We would ask for 2,500.
2,500 ROR and count 2. Battery. What's your recommendation?
1,000.
1,000. Step in the back, please. Alexander Buitrago.
Your Honor, Mr. Alexander has 2 probation warrants, no bond.
Yes, ma'am. I find probable cause for the charge of sale within 1,000 feet of a park, unlawful use in a communication device. On count 2, the bond will be $2,500. Count 1, the bond will be $5,000. Hold for the violation of probation. Justin Benori,
Your Honor, he's on felony bond on F2512733.
he is to be held
Judge, I would ask if you, we'd like to waive reading the charge.
counts 1 through 25, $5,000 each.
I believe standard bond is 2,500. Would you?
Is
want
my
to set
my standard bond is 5,000. I'm looking for the second count, counsel, if you can find it.
It's number 19 in the list.
I just saw it.
Yeah.
$2,500. That would be count number 25, 26.
And no hold, correct, Judge?
Yeah, there's a hole for,
Judge, it looks like he was arrested June 18th for his other charge and then this charge after they investigated it, but it initiated from the June 18th arrest. I know, I know, I know.
how much is the bond on the other case?
Hold on, hold on. 5,000.
What are the other charges?
The felony battery charge.
So yeah, DV felony battery.
If I hold him on that other bond, will he go see the judge tomorrow?
Yes, Judge, but if he gets arrested on that case and they take his phone, and then after that, they review his phone and he hasn't had it, he has not had any behavior that he has incurred that would be a violation of his release terms. So he's done nothing to violate his release terms.
I
They're just
understand.
saying that upon their investigation-
Do you think that the judge might want to know whether or not he had other offenses that he had committed that the judge was not aware of when they set the bond on the battery, that it would be relevant for the judge to be able to review that bond?
Judge, I think he hasn't violated the terms of his release. So although they might be interested in knowing it, it's not a violation of release terms, and I don't believe Your Honor has any authority to hold him because there's been no new behavior. If this was additional behavior that happened after he was released, then he would be in violation of his release terms. But since they
Right.
took his phone and the charges are occurring from their investigation of a phone, then no, Judge, I don't believe you have any authority to hold him on that other case.
And that is correct, unless the state files a motion to revoke the bond on the other case or to increase the bond. So I will not hold them on that other bond and will pass these cases to run its due course.
Thank you.
Francisco Frexis Pereira.
Bonded out.
Taiwan Watkins.
Bonded out.
Jason Loisel?
There is a bail bondsman in the chat for them that announced.
Mr. Loisel is before the court, charged with strong arm robbery, as well as misdemeanor battery. I find probable cause.
It looks like Mr. Loisel surrendered himself to the police department according to the arrest form. I
Yes,
see no
ma'am.
prior history. And would your honor consider a $5,000 bond for count one?
I will. $5,000 for count one. So count two, 2,500,
Standard's 1,000,
a 1,000
yes.
with no contact order. Enter. You're to have no contact with YH. Do they live together?
No, Judge.
All right. Would you like to affirm? Dedrick Andrews.
He's a violent felony offender of special concern. He's on probation on F232387A.
State, is there any information in the A report with regards to criminal mischief?
There is not. And furthermore, these should be unoccupied conveyances, as the narrative states, not the occupied as he was charged.
When I enter an order prohibiting contact with Rolando Sanchez Cabrera, Setlin Brown, Israel Perez, Juan Carlos Alonso, Raul Gonzalez. I'll find probable cause
Judge, with
for,
regard to probable cause, all it says is the following case numbers are associated with the defendant, vehicle
The-
burglary charges.
the defendant has been identified in 5 unoccupied vehicle burglaries where the victims were followed from their financial institutions after withdrawing cash.
It doesn't state the date when these incidents are alleged to have occurred. It doesn't really give us any information about the facts of the case. It's just a one conclusory line. And they don't say how he's identified. What facts do they have to support that conclusion?
I believe they also said how he was identified with his vehicle, which was impounded, so it means he was found inside the vehicle.
And that they're saying that his vehicle.
I think there's enough for probable cause, but if you want a statement of particular, we'll pass it till tomorrow. It'll be held until tomorrow.
So reset tomorrow for probable cause hearing.
In the meantime, he's detained also on the violation of probation. Ricky Merritt,
Your Honor, he's on probation F24-24546.
thank you, ma'am. He's before the court charged with possessing cocaine and paraphernalia. It's also charged with felony petty theft. I went there an order prohibiting contact with the Family Dollar located on Maury Drive. The felony petty theft, the amount will be $2,500. Possession of cocaine, the amount will be $2,500. 500 on the paraphernalia. Hold for the violation of probation case. Pablo Barrios Sosa.
Mr. Barrios as a whole for immigration, Your Honor.
Find probable cause.
Spanish, please.
Yes, this interpreter is here. Bien, señor, se ha dicho de que usted tiene un auto de detención de parte de las autoridades de inmigración. El señor juez encuentra causa probable para la acusación.
La acusación, the charge is possession of cocaine.
La acusación o cargo es tenencia de cocaína.
Judge, I'd ask you to find no probable cause. They're just saying they found a small crack rock. They don't indicate what the substance is.
Su señoría, yo le pido que no encuentre motivo fundado para el cargo. Solamente encontraron una piedra pequeña de cocaína en piedra, crack. No saben qué tipo de sustancia es.
What is commonly known as crack?
¿Qué es lo que se llama comúnmente como cocaína en piedra?
Counsel?
Abogada.
Are you asking me or her?
No, I'm asking Ms. Corey. She claims that crack is not known as cocaine. I'm trying to figure out.
Well, there's cracks in rocks. He's not describing that, Judge.
I find probable cause, your bond is $1,500.
Encuentro de que sí hay motivo fundado. Su fianza es de $1,500.
Austin McKay.
All right, let's talk about that. This was a whirlwind of a docket before Judge Chris Martin, and we covered everything from no contact orders to questions about bond authority and probation holds. Right off the bat, you could tell Judge Martin was sharp and well-versed in the procedural web of pretrial conditions, especially when it came to defendants with multiple cases or complex release situations. One of the more interesting moments came during a debate over whether a judge has authority to hold someone on a separate case after new evidence was discovered, specifically data from a phone search. The defense made a compelling argument that no new behavior had occurred posturally, so it wasn't a violation of release terms, and Judge Martin agreed. That was a nice little moment of legal clarity that showed the system working exactly how it's supposed to by the book. No shortcuts. Now, let's talk about defendant behavior. We saw a range from the visibly confused Mr. Land, who apparently cannot return to Harbor Freight, to Alexander Petraglio, whose probation warrants left no wiggle room. But perhaps the most striking was Mr. Loisel, who turned himself in on a strong-arm robbery charge. There was no drama in his presentation. He appeared calm, and there was even a bail bondsman chiming in from the Zoom chat. For someone facing a serious allegation, that kind of straightforward approach tends to play well in court. On the flip side, we had a curious moment in the Pablo Barrios Sosa case. The interpreter was brought in to clarify the charge, and there was a brief linguistic debate over whether crack is known as cocaine. Let's just say Judge Martin didn't entertain the semantics. That bond was set at $1,500 with no issue. Throughout the hearing, the state and defense each had their moments. Some of the prosecutors were on point, especially when articulating bond recommendations with clear rationale. Others stumbled a bit, like the one trying to locate count 19 mid-hearing. But hey, it happens. Judge Martin showed patience without letting things drag, and that's a skill. The courtroom atmosphere was mostly professional, with a few scattered moments of humor and informality, like when multiple defendants were listed under various spellings of James, prompting a brief game of which James is it. It gave the hearing a human touch without undermining the seriousness of the proceedings. In the end, this hearing showcased how complex bond court can be, especially when you've got overlapping cases, multiple defendants, and questions of legal authority. Judge Martin kept it moving, applied the law, and made sure each case got its due. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,